GT, a child versus Department of Children and Families. May proceed.
May it please the Court, Mary Kay Brennan for the child, JT. May I reserve 4 minutes for rebuttal?
How much?
4 minutes.
All right.
The issue before the Court today is Florida Rule of Juvenile Procedure 8.350 and whether it allows for the involuntary commitment of a 16-year-old child on the basis of an expert's written report, unauthenticated written report. In the instant case, the Court found that the report of the qualified evaluator was sufficient evidence that this child, GT, required involuntary commitment in a residential mental health facility. The child's position is that finding violates his constitutional rights to due process and is unsupported by substantial competent evidence in the record.
Well, there's nothing explicitly in Rule 8.350 that requires the evaluator to be present or otherwise testimony. To give testimony, is there?
No, there isn't, Your Honor.
Presumably, before the Supreme Court decided its opinion in MW versus Davis, it appears that these reports simply routinely came in, did they not?
I think that those reports came in subsequent to 2000 when MW was actually decided. I believe that they came in, Your Honor, as a result of a statutory amendment that the legislature required the suitability assessment prior to Medicaid funds being used.
Does the requirement of a hearing now, as a result of the adoption of the rule and subsequent statutory revisions, require now that the evaluator either appear at the commitment hearing and give testimony or otherwise be deposed and provide testimony?
There is no requirement in the rule that way, Your Honor.
But I believe your position is that the requirement in the rule for an evidentiary hearing does require somebody, when a matter is contested, to present evidence or to testify or otherwise present evidence that the criteria for involuntary commitment are met. That's
correct, Your Honor. That's our position.
Now, we are talking about a mental institution.
We are talking about a residential mental health facility, yes, Your Honor.
And among the criteria, although there's some confusion about what precisely they are, there's a requirement that the that the department establish that there's some mental illness, something that you can find a reference to in the Diagnostic and Statistical Manual.
They refer to it, I believe, Your Honor, as emotional disturbance.
Right, but if you follow that through the statutes, you find eventually references to the Diagnostic and Statistical Manual, the DSM.
It's implicit, yes, Your Honor.
Well, I think it's explicit if you trace it through.
Unlike the procedure required by the Baker Act, where obviously there has to be some testimony, the criteria under the Baker Act is far more stringent, is it not, in that there has to be a showing that the person sought to be committed is either a danger to himself or a danger to others. What we're talking about here is that there be some evidence, competent evidence, showing that the person have an emotional disturbance. Am I correct about that?
Yes, Your Honor. In this instance, the judge made a finding that the child was a danger to himself and others.
Well, that wasn't required.
It was in response to the child's challenge to the statute that simply requires a finding of emotional disturbance. The court explicitly found that the child was a danger to himself and others.
Well, notwithstanding that, but we're talking about the statutory requirement. If all the statute requires is that there be a finding that the child is emotionally disturbed, is it necessary that the evaluator, on whose opinion the placement is made, give testimony?
Yes, Your Honor, because an emotional disturbance is still a mental condition. It's, for children, it's determined to be the catch-all phrase. There's a reluctance.
Well, it could be the evaluator, or as far as the rule says, it could be some other mental health expert.
Correct,
It could
Your
be
Honor.
another psychiatrist.
Correct, absolutely, Your Honor.
Supposedly, or perhaps a psychologist. But in this case, there was neither.
Correct.
In other words, at the evidentiary hearing, the department did not produce anybody who claimed to have any expertise about which 16-year-olds are mentally ill and which are not.
That's correct.
And yet it was at that hearing that the decision was made to commit him involuntarily.
Correct.
Now, if I understand correctly, this same child had, on another occasion, been Baker-acted.
He had been Baker-acted by the facility in which he was residing on 2 occasions in August of that year.
Right, now this is really maybe taking us too far afield, but why don't they do that again? Why don't they call up and how long did the facility keep him on that occasion?
I believe the last time might have been, I don't think it was in excess of 48 hours. I think he was released the next day. And to answer your question, they could have, if they felt that he was a danger to himself or others, they could have Baker-acted him.
Well, he was placed.
So they want something else here, right? They want a placement. In other words, he's in their custody. He's a handful. And so they think, let's put him here, maybe until he's 18 or 21 or something. Is that correct?
That's my belief, Your Honor.
His prior confinements under the Baker Act, I suppose, were in emergency shelters where he could be held for what is a maximum of 72 hours.
Yes, Your Honor.
So he wasn't in any long-term facility before this time.
No, he was never. They never petitioned to put him in an involuntary placement. They just held him for evaluation, pursuant to the.
But under the Baker Act, if the authorities had thought he was an appropriate subject for long-term hold, they could have filed such a petition.
Absolutely, Your Honor.
I have to say, I wonder too, as a taxpayer, if this is a good use of the limited resources of how many beds are in this center?
Are we talking about the crisis stabilization
No,
unit
I'm talking
or the
about
residential
where they're
placement?
proposing to put him now.
There are 12 beds in the facility, and it's the place that which is in the record, the temporary group home that he was in. There was testimony that it cost approximately $295 or $75. So, Your Honor's point is excellent. It is and that was a transitional group home. Supposedly a temporary place until they could get him into a residential facility, which is more costly.
All right, but what I mean is, they've got 12 beds in Jacksonville. Maybe they have a lot more. I don't know.
Total, I don't know within the system. But the way this child was placed was Lake City. He was in a residential mental health group home with 12 beds.
And this is not the worst teenager I've ever heard about. His art teacher came and testified for him.
I heard
his art teacher appeared at the hearing?
His art teacher and his guidance counselor both appeared for him.
And what did they say at the hearing?
They basically said that the child was no problem at school, no disciplinary problem. His only infractions were 2 very minor things, that he hung around with a good crowd, and at that particular high school, he had other options. There were other that there were a tougher group of children that he could have associated with, but he did not.
And now what about the director of the temporary home? She also testified, or the vice president of operations?
Leslie Wells did testify. And she testified as to the cost and the fact that normally children are only in that facility for a very limited time, generally several weeks. He had been in there, I believe, around 3 months, and that they did not provide a lot of services to him while he was there, the very services that the state was arguing that the child needed. For example, therapy.
And how was he doing in school?
He was doing pretty well up until at the end of September. He was doing very well. At the point of the hearing, the two hearings, one on November 7th and one on November 16th, he was not doing well in 2 of his courses, and he was in grade recovery. This child has a problem in math, and he was having a problem in biology.
All right, well, I see you're down almost to your 4 minutes, if you wanted to save that.
Yes, Your Honor. Thank you.
Thank you, Your Honor. May it please the court.
Now, this was not a problem that the department asked for, right? Isn't it the case that one day this child's mother showed up with him and said, "I can't handle him here. You all take over"? That's
correct, Your Honor. That is the reason that the child was originally brought into care, was that the mother was unable to care for the child. And the child, prior to the residential treatment commitment hearing, the department did file a termination of parental rights petition to terminate the parents' rights. And I saw that, and I didn't understand that. In other words, did you think that this adolescent was going to be an appealing prospect for adoption? Your Honor, I think the quest for permanency in these cases is often a very difficult one, and the statute mandates that we give parents 12 months to attempt to comply substantially with the tasks of their case plan. If they don't comply, then we have very few options for permanency of the child. And this child was not old enough for any type of long. Well, there was really no other option under these circumstances for this child other than to seek termination of parental rights and adoption. I believe he was 13, or he may have been 14 at the time that decision was made. But you are correct, Your Honor. He is, without a doubt, a child who would be difficult to place for adoption within the facility.
Prior to the report by Dr. Filippi?
Yes, sir.
Who is a licensed psychologist, which said that the child suffered from bipolar disorder, post-traumatic stress disorder, oppositional defiant disorder, among other emotional disturbances. Had the child previously been diagnosed with a mental illness?
Prior to coming into care, Your Honor?
Yes.
Your Honor, I am not aware of the answer to that question. I believe he had been diagnosed with similar disorders that Dr. Filippi related. Dr. Filippi reviewed the child's psychiatric history.
Well, he'd been under care of
he had been prior. He had been shortly after he came into the department's care, Your Honor. But as far as whether he had been in care prior to the department's removal of the child from the home, I just briefly looking at Dr. Filippi's report, which was offered in the evidence as part of the record, Your Honor, I don't see that there was any prior history made available to. Oh, yes, Your Honor, there was the history in Dr. Flippy's report does indicate that Gary was would it be appropriate? I mean, that is part of the record, Your Honor. I guess it would be appropriate to read that.
All right.
Does state on page 309 of the record, at the top of the page, that Gary was hospitalized in Georgia on 8/14/02 after he alleged that he had overdosed on his medication, which was Paxil. So assuming that that's true, Your Honor, he would, 2 years prior to his removal from the home, have been prescribed Paxil by a treating psychiatrist. Then he was Baker acted, again quoting, Your Honor, he was Baker acted to Mental Health Resources Center on 11/30/03 after he threatened to kill himself. That was a year before his removal from the mother's home. So yes, Your Honor, he did have a history.
Now, all of this information comes from the very report that we're talking about here.
Yes.
In other words, this is the report that was challenged at the hearing as hearsay.
That's correct, Your Honor. And, Your Honor, if I may briefly address
before you go into that, though, from other witnesses, though, there had been observations, I believe, of disruptive behavior. No other witness, of course, other than Dr. Philippi, gave any information regarding his mental health status, I believe. But there was, I guess, a plethora of problematic, disruptive, and destructive behaviors by the
Yes, Your Honor. The targeted case manager who worked closely with the child testified. The vice president of the facility, the transitional facility that he was residing in at the time of the hearing, testified, and the caseworker testified, the guardian ad litem volunteer testified, and the director of the home in which he was residing all testified. The director of the home, I think her testimony was most telling as to his the behaviors, and I think those behaviors that she testified to that were included two recent Baker acts within the last few months for aggression towards others, and I think that was the basis of the lower court's finding that the child was a danger to himself.
Didn't it develop at the hearing that her testimony, too, was largely hearsay?
It did, I believe.
That she wasn't really present when he got all upset about being told to clean his room and so forth.
I think she was present a good bit, but yes, Your Honor, she did. I did on cross-examination that was brought out that a good bit of the testimony that she gave was hearsay. However, if I may address that, it's the department's position that this hearing that's been set forth in Rule 8.350 is a, and if I could quote from the Florida Supreme Court's opinion in which they adopted the rule, which is cited in my brief, Your Honor, they stated...
I'm sorry, which opinion?
Excuse me?
Which opinion?
Your Honor, that would be...
You mean the initial opinion adopting the rule?
Well, Your Honor, I say it's an opinion, but I guess it's not actually an opinion. It's the amendment to the Rules of Juvenile Procedure, Florida Rule Juvenile Procedure 8.350, 842 Southern 2nd, 763. And that was in the year 2003. It's cited on page 8 of my brief.
That was the amendment, I believe, to 8.350, I think. Was it not?
Well, Your Honor, I believe it's when they adopted the rule for the first time. It was an amendment to the rules, but I believe that the rule didn't exist at all prior to that time. And that was the rule that the Supreme Court adopted in response to him.
You'll find that the rule was adopted in, I believe, 2001. 804 Southern 2nd, 1206. The rule was amended in 2003, 842 Southern 2nd, 763.
Thank you very much, Ron.
Go ahead. I'm sorry I interrupted you.
In that, I call it opinion for want of a better word, amending the rule, the court made the distinct statement that that they were giving the child, in adopting this rule, they were giving the child a meaningful opportunity to be heard. And they contrasted the meaningful opportunity to be heard with an evidentiary hearing. Justice Parente specifically said, are we going to give the child an evidentiary hearing, or are we going to give, although I'm paraphrasing, the child a meaningful opportunity to be heard? And the Supreme Court, according to my reading of her opinion, opted for a meaningful opportunity to be heard. So this is not really...
In other words, this language in the rule, which says that all parties shall be permitted to present evidence and witnesses concerning the suitability of the placement, was simply intended to carry out that language of Judge Pariente's, giving the child a meaningful opportunity to be heard.
Yes, Your Honor. That's
Did I understand you correctly? Did you say that on the one hand, there's a meaningful opportunity to be heard, on the other, there is an evidentiary hearing, and that a rule that says all parties may present evidence is not providing for an evidentiary hearing?
Your Honor, the distinction I'm trying to make is that the hearing that is supplied in Rule 8.350 is not an evidentiary hearing to the extent that the rules that are applicable or in use in civil cases apply. The evidence rules apply. As I stated in my brief, Your Honor, the rule that applies to dependency adjudicatory hearings and dependency termination of parental rights hearings, the rule that applies states that evidence the rules of evidence that apply in civil cases shall govern. However, in disposition hearings, Your Honor, and in judicial review hearings, the rules of evidence in civil cases do not apply. Instead, the Supreme Court has adopted rules that specifically say that all relevant and material evidence may be entered, whether or not it's competent under the rules of evidence.
Well, let me ask you this. What about, you have a situation like under the APA or in a probation revocation hearing where evidence may be allowed in but cannot be the basis for a finding of fact.
Your Honor, I'm unfamiliar with those rules, but it's not quite what I'm saying, because I think that when you, for example, have a judicial review by the lower court or a magistrate judge, any psychological report pertaining to the parents, the caretakers, or the children is considered by the judicial authority and can be the basis for finding of fact in the judicial review order that results.
Now, you say there's a provision in the rules to that effect.
That doesn't specifically say what I just said, but it does. The rule that I'm referring to, Your Honor, is Rule 8.415, which pertains to judicial review of dependency cases. And subsection E refers to the information available to the court. Quote, at the judicial review hearing, the court may receive any relevant and material evidence pertinent to the cause. This shall include written reports required by law and may include, but shall not be limited to, any psychiatric or psychological evaluation of the child or parent, caregiver, or legal custodian that may be attained and that are material and relevant. This evidence may be received by the court and relied on to the extent of its probative value, even though it may not be competent in an adjudicatory hearing.
Right now, there is no provision like that in the rule that we're talking about now, is there?
There is not, Your Honor. But what I'm trying to say, and what I'm trying to do, is we're sort of having to try to figure out what the Supreme Court intended. And I'm saying that when Justice Parente makes the distinction between an evidentiary hearing and a meaningful opportunity to be heard, she is basically saying we are not going to have this become a full-blown evidentiary hearing.
I'm sorry, the language from the rule that you just read, what rule is that again, please?
Your Honor, that is Rule 8.415 in the judicial...
Dealing with what? What's the subject of it?
Judicial review of dependency cases. And, Your Honor, that is cited in the answer brief for the department on...
Okay. Does it make any difference, just referring to the language of 8.350, I'm looking at, I guess it's subsection A11, hearing on placement. And under A it says, at the hearing the court shall consider at a minimum all the following, and subsection IV, the written findings of the evaluation and suitability assessment prepared by a qualified evaluator. And then you have a separate subsection B, which has the provisions we already referred to, saying that all parties shall be permitted to present evidence and witnesses concerning the suitability of the placement. Does that indicate to you a separation of the presentation of the evidence, i.e. that the written findings of the evaluation may be admitted for determination of placement, separate from the requirement of presentation of evidence and live testimony before the court?
No, Your Honor. I think that since the way I read that rule, Your Honor, is that since hearing on placement is number 11, and then within it is subsection A and subsection B, I consider that both A and B apply to the single hearing.
Well, yes. I didn't mean to suggest that it was separate. In other words, but I did mean, frankly, I was trying to help you, I must admit, that in other words, that the written findings of the evaluation could appropriately come in before the court, whereas other types of testimony, i.e. witnesses, and as you've already referred to, that statement by Justice Pariente that the child will be able to present testimony in his own behalf, or witnesses in his own behalf. In other words, there is a difference. It seems to me that the rule is suggesting there is a difference in form in the presentation of the type of evidence.
Yeah, absolutely, yes, sir. That's what I'm trying to argue, Your Honor, is that the court specifically wanted this to be more like a judicial review than an evidentiary adjudicatory hearing.
I will extend your time a little bit. Judge Benton's got a question for you.
Oh, I just wanted to follow up on one thing. You heard opposing counsel say that, in response to a question that I asked, that it may be that it's the department's plan to place this child in this setting and hold him there until he ages out of the system.
Yes, sir. I heard that.
Is that a what do you say to that?
Well, Your Honor, the rule provides for within 30 days of the department, within 30 days of the order placing the child in residential treatment, the department has to file a 30-day an initial treatment plan from that facility with the court. The court ordinarily sets, I think it may be required in the rule, a hearing within 30 days to assess that initial treatment. I'm not sure if it's required, but it's normally held. It was in this case. And then, Your Honor, we have the rule requires 90-day review hearings in front of the court, and the department is under the obligation under this same rule to provide 90-day review assessments from a suitability assessor, the same type of qualified psychologist or psychiatrist that did the initial suitability assessment. So there's not certainly you can make that observation, but the rule is calculated to have the opposite effect, to actually try to get the child out as soon as possible. And in fact, speaking totally outside of this case, my own experience has been on a number of occasions that in an effort to save money, Medicaid will often try to get not Medicaid, but whoever's the suitability assessor will often try to step down the child from treatment a lot quicker than people in the department would prefer. So I don't think that the Supreme Court has set up a system that is going to place the child there until they're 18. I think, on the contrary, they've set up a system that there seems to be a motivation to get the child out as soon as possible.
Aside from the written findings of the evaluation, was there any other evidence supporting the determination that the child was emotionally disturbed?
Your Honor, there was no professional opinion from a psychiatrist or psychologist to that effect, other than the opinion of the suitability assessor. However, Your Honor, if I may, that is all that's required by the rule. The rule states in the provision that you quoted that is all that is required.
Well, if we interpreted the rule to be that, to say that which it appears to say, that these findings of the evaluation are admissible, would there be some serious concern with due process, i.e. that the child is not given the opportunity to cross-examine the author of the evaluation on whose the report of which is on which the finding of emotional disturbance is based?
Your Honor, I think that the decision of MW is what authorizes this type of procedure. And I think that the Supreme Court said in MW essentially that it's okay to have a non-full-blown evidentiary proceeding because the judge is familiar with the child, because the judge has judicial reviews, the judge has been on the case oftentimes since the beginning, which was the case here. So the need to have due process to the extent that the suitability assessor must be present to be cross-examined is not that great. I think MW addressed that, Your Honor, but not specifically because the suitability assessor was not in existence at the time.
Okay. Well, thank you very much. Appreciate it.
Thank you.
If I may, Your Honor, just very quickly, you needn't be a psychiatrist to prescribe Prozac or any antidepressant, or basically any drugs for that matter. You just need to be a licensed physician.
So this is a reference to the Paxil?
This is a reference to the Paxil, yes, Your Honor. This is a mental health commitment. There's a long line of mental health cases from this district and from the state Supreme Court as well as the United States Supreme Court. This child does not lose his constitutional rights relative to this involuntary mental health commitment simply because he is a ward of the state. And trying to say that the hearing under 8.350 is a dispositional hearing or judicial review just is contrary to the facts. It's a mental health commitment and due process.
All right, so if he were not a ward of the state, he would have substantial protections under the Baker Act.
Correct.
Including under N. Ray Beverly, the full right of cross-examination of every witness.
Correct, Your Honor. Furthermore, when Justice Harding talked about the right of counsel, he cited Lynch v. Baxley. Lynch v. Baxley at 394 specifically refers to, and Lynch v. Baxley was an involuntary commitment case, specifically refers to the right to cross-examination. There's our own case, the Pullen case, citing Schumann, where the court has said the interests and policies are most like those of persons incarcerated. This child wasn't given an opportunity to question any of the medical evidence that formed the basis of the judge's opinion.
Well, before the child was accorded, or children were accorded, the right to a hearing, obviously there was a very informal placement of these children into residential treatment facilities. And I think it's rather clear that before MW was decided, that routinely these children were placed in facilities based upon the evaluator's written report.
That's true, Your Honor. And the interesting thing about MW is that Justice Pariente actually talks about the challenge being in the form of a habeas corpus rather than an appeal. And I interpret it as suggesting that the arguments, the constitutional arguments, were thus limited because of the form of the challenge. This is not the case here. We believe that this child is entitled to the same constitutional.
The thing that disturbs me a little bit about your argument is that MW did not seem to think that that procedure did not comport with due process, that is, the prior procedure. They did, clearly MW recommended the adoption of a rule that would perhaps provide greater protections to the child, somewhat similar to a person who was Baker acted. But it never explicitly stated that without a hearing it would necessarily be a deprivation.
Well, Your Honor, Justice Pariente noted the irony of the fact that children in delinquency proceedings who have actually done something wrong were entitled to much more constitutional protection than these children who have done nothing wrong. And her reference to in the commitment of NN, wherein the New Jersey Supreme Court knocked down the beneficial test for involuntary commitment, I agree that the decision leaves many of us with different interpretations, but I think it could easily be interpreted, especially with its reference to in the commitment of NN, to suggest that the full panoply of due process rights should be afforded these children in these hearings. Thank you.
Thank you very much. We stand adjourned.